Late because I think there were not enough delegations in the room and we were trying to give more time to the delegations to come back. In the second half of today, we have a special meeting on extraterritorial application of national legislations, sanctions imposed against third parties. I will now give the floor to the Secretary General of ALCO to introduce the subject. You have the floor, sir.
Thank you, Madam President. Madam President, Professor Vera Gauland-Dabas, Professor of International Law, Graduate Institute of International Studies, Geneva, Professor M. Gandhi, Professor and Executive Director, Center for International Legal Studies, Jindal Global Law School, Professor Rajesh Babu, Indian Institute of Management, Calcutta, Dr. Rohan Pereira, Excellencies, distinguished delegates, ladies and gentlemen. It is my pleasure to welcome to the special half-day meeting on the topic of extraterritorial application of national legislation, sanctions imposed against third parties, organized by ALCO in collaboration with the Government of India. At the outset, I would like to formally welcome and thank all the panelists for taking time from their busy schedule to be part of this discussion today and to provide us with their valuable insight into the topic at hand. The agenda item entitled Extraterritorial Application of National Legislation, Sanctions Imposed Against Third Parties, was placed on the provisional agenda of the 36th session at Tehran, 1997, following a reference made by the government of the Islamic Republic of Iran. Thereafter, the item had been considered at the successive sessions of the organization. At last year's 51st annual session of ALCO in Abuja, Resolution ALCO/REAS/51/S6, the Secretariat was mandated to undertake a special study on the legal implications of the application of unilateral sanctions on third parties. The Secretariat is proud to announce that this study, entitled Unilateral and Secondary Sanctions, an International Law Perspective, has been completed and would be released soon. An executive summary of the study, as well as the contents page of the study, has been distributed for your perusal. Madam President, the topic of unilateral sanction is of particular importance to ALCO, as some of its member states have been the targets of unilateral sanctions in the recent past. Indeed, the topic is also of great relevance to the wider community of developing nations, as well as this community exclusively finds itself the target of such sanctions. Sanction, as we all know, in international affairs means a penalty imposed against a nation to coerce it into compliance with international law or to compel an alteration in its policies in some other respect. Legitimacy of sanctions under international law is applicable only to multilateral sanctions which are applied as per Chapter 7 of the Charter of the UN. The Security Council is vested with the primary responsibility for maintenance of international peace and security under the UN Charter. Unilateral sanctions often refer to economic measures taken by one state to compel a change in policy in another state. The most widely used forms of economic pressure are trade sanctions in the form of embargoes and or boycotts, and the interruptions of financial and investment flows between sender and target countries. However, while the common conception of unilateral sanction is as a tactic by which a state refuses to maintain trade relations with a country whose policies it disagrees with, or with whom it has a dispute, this unilateral sanction also give rise to secondary sanctions. These secondary sanctions are imposed against third parties, either states or non-state entities, who are outside the jurisdiction of the sanctioning state, in order to prevent them from trading with the target state. Essentially, this results in the sanctioning state enforcing its own domestically enacted legislation against entities that are outside of its territory and jurisdiction, thus resulting in a violation of some of the most basic principles of international law. Excellencies, the study conducted by the ALCO Secretariat deals in detail with the violation of international law by unilateral and secondary sanctions, and these violations can be broadly divided into 4 areas. The first chapter provides the genesis of the subject within ALCO, how sanctions have been listed under international law, and the political economy of sanctions regime. It also briefly describes the concepts like extraterritorial jurisdiction, unilateral sanctions, secondary sanctions, and collective or multilateral sanctions. Chapter 2 argues that unilateral and secondary sanctions are impermissible under international law. The foundational principles that regulate and govern international relations are stated in Charter of the UN and the authoritative 1970 Declaration of Friendly Relation and Cooperation among States. These include the principle of sovereign equality of states, principle of non-use of force, the principle of self-determination of people, the principle of non-intervention into the internal and external affairs states, the principle of peaceful settlement of international dispute, the principle of cooperation among states, and the principle of fulfilling in good faith obligation assumed under international law. Madam President, Chapter 3 attempts to highlight the adverse effects of financial sanctions that are imposed against financial institutions, especially the central bank of an economy, which hampers the effective functioning of this institution in developing countries. The role played by the central banks in achieving development in developing countries is very pivotal. The central bank has a crucial function towards developing the banking and financial system of the country in order for ensuring well-organized money and capital markets within the economies. The main contention is that since central bank has a major role and function in regulating financial system of country, they should be granted immunity and their property shall not be attached. Chapter 4 attempts to elaborate on the adverse effects and the illegality of unilateral and secondary sanctions in the context of international trade agreement, be it multilateral or bilateral, and freedom of trade and navigation. It highlights the violation of the core principle of international trade law vis-à-vis multilateral trade agreements and bilateral trade treaties with analysis which analyzes the impact of the secondary sanction on third parties with country-specific examples. The chapter suggests possible measures for the developing countries against the imposition of unilateral and secondary sanction. In other words, the possible legal options for the third countries to respond to the secondary sanction. Chapter 5 focuses on the list of recognized human rights that are adversely affected by sanction is long and varied, but the discussion within this chapter is limited to some of the more pertinent rights, particularly in view of the fact that the targeted states are developing and third world states. The rights discussed will include the right to self-determination, the right to development, and the right to life, with particular attention paid to the right to food and the right to health and medicine. While a classification of the importance of rights is obviously not possible, these particular rights were chosen for their relevance to the developing world and because of the massive problem caused by their violation. Chapter 6 addresses the responses of the international community on the imposition of unilateral and secondary sanction. This chapter deals with the opinions voiced by some of the international organizations as well as their member state in the forum provided by the organization through resolutions and statement of the organization. These include the UNGA, ALCO, the Group of 77, and the Non-Aligned Movement, which form part of in-depth analysis for evolving evidentiary customary international law. The study contends that unilateral and secondary sanction is against international rule of law and promotes self-interest. Unilateral and secondary sanction affect trade relations of the target country as well as its trading partners, affect the economic and banking system, besides inflicting suffering and deprivation of basic human rights on innocent civilian population of the target countries. These sanctions disrupt international trade and navigation and are impermissible and unjustifiable under international law. In addition to the theoretical discussion in the study regarding international law and unilateral sanction, illustration of the practical aspects and real-world consequences of unilateral sanction regime will be done through the use of the case study of certain countries who have been the targets of sanction, primarily Iran. Madam President, Excellencies, ladies and gentlemen, I hope I have been able to highlight the salient points relating to ALCO's special study and that I have given you a brief overview of some of the pertinent issues relating to the topic of extraterritorial application of national legislation, sanctions imposed against third parties, in an effort to set the stage for the discussion that is to follow. I have no doubt that the discussion that is to follow will be extremely illuminating. I thank you, Madam President.
Thank you for introducing the study. We have 4 eminent panelists here today. Dr. Rohan Pereira, who needs no introduction, who was our panelist in the morning also, former member of the International Law Commission and the chairpersons of Eminent Persons Group of ALCO, would initiate this discussion by speaking on the subject, sanctions and international law. You have the floor, sir.
Thank you, Madam Chairperson, Mr. Secretary General, distinguished panelists, and distinguished delegates. The task before me this afternoon is somewhat of a difficult task because I'm virtually filling in the shoes of Professor V.S. Mani, who was supposed to have addressed the meeting on the question of sanctions and international law. Since he's unavoidably held up, I've been requested to make some remarks on this aspect before the specific aspects are developed by the eminent experts who are on this podium. By way of setting the backdrop, Secretary General just referred to the legal framework, post-United Nations legal framework, regulating interstate relations, primarily the UN Charter, and of course the 1970 Declaration on Principles of International Law, governing friendly relations and cooperation among states, contained in Resolution 2625. We also have the draft declaration on rights and duties of states, developed by the International Law Commission. Although it is in draft form, it is of considerable persuasive value. Now, these collectively constitute the edifice of core principles governing international relations and, of course, maintenance of international peace and security. We all know what these core principles are. Secretary General just referred to them, the principles of sovereign equality and territorial integrity, non-use of force, non-intervention in the internal affairs of states, and international cooperation and solidarity. It may be worthwhile to recall at this juncture the judgment of the ICJ in the Nicaragua versus United States case, where the ICJ took the view that these fundamental principles exist both as charter provisions and as customary principles of international law. And on that basis, the ICJ was able to overcome the jurisdictional objection that was taken by the United States. The objective of sanctions, and if I'm to quote from this very useful publication by the Secretariat, unilateral and secondary